Roe versus Wade is the name of a Supreme Court decision from 1973 in which the Supreme Court ruled 7-2, 7 justices in favor, 2 dissenting. The Supreme Court ruled that the right to procure an abortion was a constitutionally protected right. That by the Constitution, people have the right to procure an abortion. It also set out some guidelines for how that right could be limited in certain ways, which we'll get to in subsequent videos. But it has set, Roe versus Wade has set the law concerning abortion since the decision, since 1973. What I want to do right now is discuss some of the background, just so that we have an understanding of what's going on as we read Roe versus Wade. It's a little complicated. It deals to kind of understand how exactly it works, how exactly the justices, their decision affects the states, and so on. And so I just want to give you a little bit of background, a little bit of context for where the case is coming from and how it works. Prior to Roe versus Wade, the federal government of the United States, so the United States government proper, didn't say anything about abortion. And in virtue of the 10th Amendment, which holds that any powers not given to the United States government by the Constitution are relegated to the states. The states have authority over those areas. The 10th Amendment says something like, you know, if the Constitution doesn't give the federal government the power to do X, well, then X falls to the states to deal with. And the states, you know, Ohio, Illinois, Michigan, whatever, they can do what they see fit with regard to X. The 10th Amendment says something like that. Given the 10th Amendment, the thinking had been, prior to Roe versus Wade, the thinking had been that abortion was a state's issue. And so states could do what they like with regard to abortion. And so if states wanted to allow it, if Illinois, for example, wanted to allow it, they could allow it. If they wanted to outlaw it, they could outlaw it. And many states prior to Roe versus Wade had more or less outlawed abortion. And Texas was one of these states. So Texas had a law on their books and had been on their books for, I think, over 100 years. It had been on their books for a very, very long time, which more or less completely prohibited abortion. There were exceptions drawn. I believe the only exceptions drawn were to save the life of the mother. So if the mother's life was, which happens, it's very rare, but it does happen in pregnancy where the mother's life is put in danger, and an abortion would alleviate that danger. In those cases, an abortion can be performed. That was the Texas law, but otherwise illegal. That was the law at the time of Roe versus Wade, and many other states had similar such laws, right? In 1969, a resident of Texas named Norma McCorvey became pregnant, and she wanted to have an abortion. But being a resident of Texas and being subject to the Texas prohibition on abortion, she wasn't able to procure one. Norma McCorvey then brought a case against the state of Texas, challenging the law that prohibited abortion. Norma McCorvey, when she filed the suit, she filed it under a pseudonym, which is regularly happens in situations like this, and filed it under the pseudonym Jane Roe. And that's where the Roe in Roe versus Wade comes from, right? It's Norma McCorvey. It's the pseudonym that she used in her suit against Texas. And the Wade in Roe versus Wade, that's the last name of the district attorney of the county that Norma McCorvey brought the suit in. And in as much as he was the district attorney of that town, of that county, he was obligated to defend Texas, right? And that's where you get the name Roe versus Wade. So she brought a suit against the state of Texas. If you've followed the Supreme Court at all and how cases get there, you know it takes many years for cases to get to the Supreme Court, and Norma McCorvey's case was no exception. It took 4 years for the Supreme Court to eventually hear her case because she initially filed suit against the state of Texas. It was heard in those courts. She had been appeals and blah, 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 this whole process, and eventually it winds up at the Supreme Court. And pregnancy, of course, doesn't last 4 years. And so you might wonder, well, what happened? Well, she had the baby and put the baby up for adoption. So that's what ended up happening to Norma McCorvey. One of the issues that we're not going to look at really at all, but it's there in Roe versus Wade. One of the issues that this case brings up is whether or not she had standing to bring the case, given that by the time the Supreme Court eventually heard her case, she was no longer pregnant. Can she rightfully bring a case? This is something that the Supreme Court deals with in Roe versus Wade. They say, yes, you can still bring the case and so on, but we're not going to get into the details of that. All right, so she brings this case against the state of Texas. It's appealed and appealed and appealed, and eventually goes up to the Supreme Court. And in 1973, when they eventually hear it, the Supreme Court rules in favor of Roe, of Norma McCorvey, and they strike down Texas's law. They deem that law, the law which more or less prohibited abortion except in cases of saving the mother's life, they deem it unconstitutional, that it infringes upon the fundamental rights or liberties guaranteed by the Constitution. That's the ruling of Roe versus Wade. And what that ends up doing is it deems not only Texas's law unconstitutional, that's the specific law that's at issue in the case, but the ramifications of the decision are much larger than just Texas, because it ends up, what Roe versus Wade does is it ends up making any law that is relevantly similar to Texas's unconstitutional and illegal. Any prohibition on abortion, illegal, unconstitutional. That'd probably be the better way to put it, right? So it not only overturned Texas's abortion law, but every other state that had similarly strict restrictions on abortion were ruled unconstitutional in 1973, right? And so Roe versus Wade overturns all of those laws. And if a state today were to pass a similarly restrictive abortion law, they could do that. It would go through their process, right? It goes through their Congress, the state Congress. Let's say Illinois wanted to, right? And so the Illinois legislature, the state legislature, gets together. They draft this law that more or less completely prohibits abortion. And the requisite number of people sign on to it, and say the governor signs it, right? This would never happen given the current politicians in power in Illinois, but let's just say for the sake of argument that this happens. That could happen. Then what would happen is an Illinois resident would likely bring suit against the law. They would say that this infringes their basic rights, their fundamental liberties, and it might eventually wind up at the Supreme Court, in which case the Supreme Court would likely say, yes, this is a violation of Roe versus Wade, this is unconstitutional, and then they would throw out the Illinois law, something like that. That's the way these court decisions work in the United States. It's a little bit complicated, right? So what Roe versus Wade really says is that states, it is unconstitutional for states to kind of aggressively restrict abortion, and that abortion, or the right to procure an abortion, is one of these fundamental liberties or rights guaranteed by the Constitution.